Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today in this video, we're going to be talking about bringing an end to a marriage by way of annulment. But before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. Marriage in Botswana can come to an end in three ways. One, where one of the spouses passes away. Two, by way of divorce, as explained in my previous video. And three, through an annulment. The question then is, what is an annulment? An annulment is where a marriage has been brought to an end by the court, and the marriage in terms of the law is seen to have never existed. Now, in order for a person to be granted an annulment, they have to approach the courts on various grounds. And in deciding whether or not to grant an annulment, the court won't just look at those factors. The court will also look at whether or not there were children born during the marriage. And this is an important point to note because, unlike with divorce that cannot be brought before the expiry of 2 years of the marriage, there are no timelines set for an annulment, meaning that an action for annulment can be brought after 3 years of marriage. So if the court looks at this and sees that they are minor children, then the court might decide to refuse to annul a marriage and grant a divorce instead. And the reason why this would be is because the effect of annulment, like I said, is that the marriage is seen by the law to have never existed, meaning that the children would be seen as children born out of wedlock. There are various grounds that can be used in order for a marriage to be annulled. The first ground is that the people that are married are in the prohibited degrees of relation, what is called consanguinity and affinity. For example, a parent and a child are not allowed to get married to each other. A grandparent and a grandchild, a niece and an uncle, a brother and sister, a grandparent and a grandniece or nephew, and so on and so forth. Additionally, if people have been married and they got divorced, then the wife cannot marry the brother or sister of their former spouse. Similarly, a man cannot marry the sister or brother of their former spouse. However, this applies for as long as the former spouse is alive. But if the former spouse has passed away, or they were married and the spouse passes away while they are still married, then the remaining spouse can marry one of the siblings of the spouse that has passed away. The other ground that can be used to annul a marriage is where one or both of the parties are still married to other people. An example, if Kaale is married to Margaret under customary law, and then Kaale goes and tries to marry or marries Thabang under common law, the marriage between Kaale and Thabang will be nullified because Kaale is still married to Margaret. A marriage can also be annulled when it is invalid under the law. For example, if one of the parties is below the age of 18 years old, because in terms of the Marriage Act, a person has to be 18 years or above in order for them to get married. If they are below the age of 18, then that marriage is seen to be invalid and therefore can be annulled. A plaintiff can bring an action for the annulment of their marriage against the defendant if they can demonstrate that the defendant has been refusing to consummate the marriage. The plaintiff can then approach the courts in order to have this marriage annulled. A plaintiff can also ask for a marriage to be annulled where the defendant is said to be of unsound mind, where this defendant, unfortunately, they do not have the necessary capacity to consent to various things. A plaintiff can ask for a marriage to be annulled if the defendant is shown to have a venereal disease, and this venereal disease they had at the time of marriage, and that this disease is transmissible. This can be used as a ground for a marriage to be annulled. And by venereal disease, I'm talking about sexually transmitted diseases. A plaintiff can also have a marriage annulled on the ground that at the time they got married, the defendant was pregnant and was pregnant by some other person who is not the plaintiff. It must be noted that if the plaintiff is the one that got someone else pregnant, then that cannot be the ground for an annulment, meaning that in terms of this ground, it can only be used against women. The other ground that can be shown for a marriage to be annulled is that the marriage cannot be consummated. It's different from the first ground because in the first ground, the defendant refused to consummate the marriage. In this instance, it's where the marriage cannot be consummated, and this could be due to medical complications or that the defendant cannot have children. That can be used as a ground for annulling a marriage. Finally, the last ground that can be used to annul a marriage is where the consent to marry was obtained either by force or through fraud. In this instance, the law looks at it as if the consent was not well informed. The person did not give this consent of their own free will. The court would look at it and agree to grant an annulment provided the ground can be proven. With that being said, I hope you enjoyed this video and you found it informative. Please make sure that you like, you share and subscribe. Ring the notification bell so that every time I put up a new video, you are informed. Make sure you put a comment down below on your views on the issue of annulment or what your views in relation to this video. Please make sure to follow me on my Facebook page at Botswana Thinking Law and follow me on Twitter at BW Thinking Law. I sometimes share small legal snippets here and there. Thank you for joining me. I hope to see you in my next video. Bye.